Supreme Court finally declared the RH law as a constitutional but with revisions on the content and provisions. The story from Angel Cordova.
After hours of deliberation by the country's magistrate on the Constitution of Republic Act 10354, or the Reproductive Health Law, the Supreme Court released its verdict on the 15 petitions filed against the law. And in their 8-page decision, the High Court stated the much-awaited decision.
The Court, after a scrutiny of the various arguments and contentions of the parties in the foregoing consolidated cases, consisting of 14 petitions challenging the constitutionality and 2 interventions to uphold the constitutionality of Republic Act number 10354, or the RH law, held that the RH law is not unconstitutional, based on the grounds laid, except with respect to the following items, and I will mention.
The magistrate's decision paved the way for the pro-RH advocates to express their support for the verdict given by the High Court. But, despite the decision, the magistrate saw 8 points considered to be unconstitutional. Among these are the referral of private and religiously owned hospital owners, health facility, and to allow minor parent and minors suffering from miscarriage to modern methods of family planning. The punishment of healthcare providers failing to disseminate information on the programs and services of the RH, allowing married individuals to undergo RH procedures without spouse consent, the punishment to be given to any healthcare provider who fails or refuses to refer patients to another healthcare service within the same facility, the punishment for public officers who refuse to support reproductive health programs, rendering pro bono reproductive health services that may affect the conscientious objector in securing PhilHealth accreditation, using the qualifier to contravene on RH law, and penalizing health service providers requiring parental consent from minors. Pro-RH advocates, for their part, said a review of the 8 unconstitutional points stated by the magistrates will follow to allow possible directions in its implementation.
Kahit sila hindi pa nila nabasa yung full official text ng ruling ng Korte Suprema. Ang sa amin, yung saya namin sa matamis na tagumpay na ito ay ibig sabihin, alam namin mayroon talagang solid ngayon at basehan para sa aming mga susunod na hakbang para kung ano man ang sinabi nilang bahagi ng mga provision o seksyon na unconstitutional ay magawan pa namin ng solusyon.
Former Health Secretary and RH convener Dr. Esperanza Cabral stressed that health practitioners will abide by the decision of the High Tribunal.
It is okay because we took an oath, and our code of ethics say that we should provide the best kind of health service that we can to whoever, no matter what the station in life is.
This is Angel Cordova for News at 1, Junior Edition.